May I prefer time on 2 weeks time on
Yes,
behalf of
yes. 2
Pratik
weeks,
Chatterjee?
why?
On behalf of Pratik Chatterjee, his personal difficulties. That's why.
Very well. On the last occasion also it
Yes,
was.
last time on Thursday. Yes.
You are there. You move the matter. What is the application for?
I don't know. I have no instruction. I am not in this matter.
On the prayer of the appellant, the matter is adjourned for a fortnight and shall next be listed in the monthly list of May 2025.
Very good.
Please give your name only.
Yes.
But I appear for the sole respondent that we had lodged a caveat. But no copy was served upon us. But she could find the. But kindly sees whether the caveat is within the record.
There is an endorsement.
Yes.
You wrote no notice of caveat. But the endorsement is caveat bearing number such and such has been lodged by Pushpa Simani.
It's our mistake.
It is pointed out by learned counsel for the alleged for the caveator respondent that no copy has been served on the said learned advocate. Pushed up. The petitioner, you are ready with a copy?
Yes, my lord. Now, my lord, the learned advocate
Has not been served.
My lord, last direction, lord. The affidavit of service is made ready. But I shall serve, my lord,
No, if I've got a copy, then it's okay.
No, but now I am receiving the copy. My client has received it, but she could not give it to me. Because we were under the impression that we had lodged a caveat, we'll be getting
Next para.
It's my mistake.
From the affidavit of service filed today, we find, however, that a copy has been served on the respondent directly. Pushed up. It is unfortunate that no copy of the application was served on the learned advocate for the caveat, despite the caveat having been lodged. Pushed up. However, since a copy thereof has already been served on the respondent directly, as well as another copy is handed over in court to the learned advocate for the respondent, uh, it is deemed that proper service has been effected. Are you ready in the matter? Can you take up
kindly
on the prayer of the respondent, let the matter stand adjourned for the day.
Wait. Could it be day after tomorrow?
Why come back tomorrow? Probate case, say usual.
Wait.
Number 20.
But I am from the.
Yes. What is the matter, please?
It's a probate decree was passed, my lord. I was directed to come up with the decree of the probate, my lord.
This is appearing for the first time.
No, my lord. On earlier occasion, it appeared, my lord. I was directed to, my lord, file the probate decree. Decree of probate, it is just handed over to
No,
me,
did you direct service of copy of the application to be effected?
No, my lord, that was not effected.
What is the application for?
My lord, application for, my lord, first 2 application was made, my lord, to for leave the file on behalf of the respondent. I am the son of the respondent who earlier filed an application under order 32 rule 15, and it was rejected by the learned trial court. Thereafter, it was preferred before this honorable court. It is pending. And during the pendency
order 30
to rule 15, my lord, mentally ill. That is the, my lord, can number 1 and cat number.
That touches the merit of the appeal also.
Yes, my lord. And can 2, my lord, for setting aside the order and stay order, my lord.
No, by virtue of the impugned decree, what has been done?
But probate decree was passed.
Probate decree has been finally passed.
Yes, finally passed.
But if serve copies and come back, and unless the leave is granted, Mr. Court, we cannot grant a stay at this point of time. Serve, how soon can you serve? Can you serve within a fortnight?
Yes.
We'll keep it on 6th of May, 2 weeks
my
after.
In the meantime, any protection, my lord?
Protection, but without the leave, we cannot, because the leave touches the merits of the appeal also. That is the difficulty.
Yes, madam.
The appellant shall serve copies of the applications as well as the memo, so that we can cut short them. The appellant shall serve copies of the applications, of both the applications as well as the memorandum of appeal on the respondent, indicating that the application shall be listed for hearing on May 6, 2025, when an affidavit of service shall be filed by the appellant. Let's come back, we'll just decide together.
I love.
Thank you. Those is called.
Item number 21.
My lord, I am for the appellant, my lord.
I am for the respondent number
Malad,
3
yes.
caveator and also
Subsequently
instructed
filed the
other
caveat.
respondent.
Other respondents.
Instructed. But
Malad,
without
this
leave
is
of
a
the
fine-
court with leave of the court to file vocalisma within 7 days. For
Within
other
7 days for the other respondent.
other respondent.
Means 1 and 2.
Three
Other
and
respondent.
four. One,
3 and 4. 3 and 4.
Your caveat is for 3 and 4.
3 and 4.
So you will file for 1, 2, 5, and 6.
Yes. Yes.
Very well, very well, very well.
Fine.
Yes, we'll grant you that leave. We are disposing of the application right now with that leave.
Yes.
Malad,
The appeal is against final partition degree, so we'll make the injunction. What order? Oh, stay order was passed.
Yes.
Let that order remain. We'll direct them to prepare paperwork.
While kindly see, the parties are not agree for preliminary degree. Share
No.
is determined.
Only the
Only the
allocation of
final-
shares.
Only
Yes.
the final degree. Final degree passed, there is a two option to the parties living. One, through auction sale property and the money divided in the ratio of 5:7, which is
It was held by the trial court that the property is not partible.
not partible.
Why?
Is
The
it the-
size is small.
Yes, size is
One-
small
one
and not divided according to the KMC rules. That was small. There was not possible to divide it into the party respective share thereof. That's why commissioner suggested to the
Sale and OLT money to be distributed.
yes, yes.
So what is
Or the either party as the settle out of court, one party can be sold to other party and other party can be sold other party. There's the commissioner's report. They are just small. And Malo, kindly see the application against the objection application filed by the my learned.
where do you find that? It's an annexure to the application.
Yes. Correct.
Which page?
Page number 93. On frivolous grounds, my lord, this is not maintainable. And on this score, he challenged the final degree.
No, let us see
And
93. What?
93,
93 is hard application. Hard objection.
their application, my lord, the appellant's application.
Appellants, yes.
dependent.
Let us see.
Kindly see, my lord, that the institute such and such, two, that the learned partition commissioner has filed his report and your petitioner has been advised to file written objection such and such. Three, that accordingly your petitioner intend to file written objection to the commissioner report. Your petitioner further states that report the learned commissioner is not acceptable to your such grounds. My lord, kindly see. The learned commissioner failed to consider that the defendant is occupying the suit property. Well, he is admittedly, after the preliminary degree was passed and before the commissioner's report also stated there, they inducted tenant intentionally on the ground floor. And he is possessing occupying the first floor. Then building is a two-story building. Ground floor inducted tenant presently after the preliminary degree intentionally to frustrate the commissioner's report as well as the final degree. I am depriving from the fruits of the preliminary degree. That is the intention of the appellants, my lord. Can you see
B,
the-
the learned commissioner failed to value the share of the plaintiffs.
Yes. The
Commissioner did not evaluate the shares.
value. Commissioner report, kindly see the commissioner's report and the final degree. Well, kindly see once first 87 page, the commissioner's field note. Page number 87.
This is the proceeding.
Proceedings. This is field note.
Internal page 2 of the commissioner's final report
Fine.
says very small property according to declaration.
Yes, and there is a valued property. Commissioners also valued the property. Kindly see the final degree, page number 83,
All right.
in order. My lord, the page number.
Yes, what is your grievance with
83.
this? What is your grievance?
Malad, my
Perfectly justified decree.
Yes, yes.
Malad, auction sale and I am in possession.
It's a small property, right?
Small
One
property.
kata, 6 chataks. How many co-sharers are there? They have preliminary degree has been passed. You cannot resist partition.
Five daughter, one
So 9 parties total. How can one kata 6 chatak 11 square feet be
Can be divided.
divided? So are you saying that you want to retain possession and you pay them the entire amount consolation? I think they'll be agreeable to that also. If they pay the entire amount and buy your shares,
Yes, yes,
you have no difficulty with that.
no difficulty. According to commissioner's valuation,
Yes,
I have agreed.
a commissioner evaluated as per the
84.
registration office slip, e-assessment slip query.
83 lakh 75,112.
No, 91 lakh something.
No, my lord, kindly see the page 83, the ordering portion last.
All right.
91 proposes. the
Structure and
plaintiff
yes,
pro-
is 83.
plaintiff proposes.
You pay their shares.
We are ready to pay all the money. They are not accepting. my lord.
You are ready to pay apart from your share, the rest of the shares you are ready to
Yes,
pay them.
Yes, my lord.
So we'll keep it after 2 weeks. You can take instruction. They're ready to pay you the money, the entire money.
But the property, my lord, the ground floor as well as the first floor, only
The entire
property
the
income.
entire property they have got a share also.
Yes.
1/9 share probably.
My lord,
The-
5 is to 7.
5:7.
Whatever be the share
This is
declared
a-
by the preliminary degree, we go by that. Regarding the rest of the shares, apart from their share, let them purchase the property. They'll pay the amount as per the evaluation of the commissioner.
As per the valuation.
So in the meantime, we'll continue this
Now,
deal.
that is the difficulty is the before by the filing of
So very well, we'll keep the application itself pending.
at the out of court.
We'll direct you to, not out of court, we'll give the contours of the settlement. That commissioner has already evaluated the property. Preliminary degree declares the share. So they will pay you your amount, consideration amount out of this, your share.
But the negotiation is going back in that regard of settlement on the valuation. My lord, my client, my lord, we intend.
Then
to-
we'll dispose of the stay application. We won't keep it
Yes,
pending. We'll make it open, keep it open
Huh.
for the parties to negotiate between
Yes, sir.
themselves. But there has to be a stay of operation. Otherwise, nothing will remain in the appeal.
My lord, there the final order, my lord, only the auction and also the, my lord, liberty is given to the parties to settle the matter.
Do that by all means.
My lord, there is,
As per direction of-
unless the, my lord, the final order stay, if the final order is stayed, my lord, I will be depriving from the suit, my lord, the indefinite, till the disposal of the suit. Kind of,
What? How will you be deprived?
my lord, the ground floor as well as the first
You have not
floor
been
was
given possession.
not in position.
The final degree does not give you possession. You have not preferred any challenge.
No, I have
It
not.
boils down to money, your share of the money. Commission has evaluated. You have not preferred any
No, my
challenge.
client intend to purchase the salary from my brother.
That is precisely what you are saying. You pay the amount and purchase the property.
My lord. My lord.
We'll continue this stay. We'll give liberty to the parties. If there is a mutual settlement, then to come back.
Right.
Learned counsel appearing for the respondent numbers 3 and 4 submits that he has instruction to appear for the other respondents, who is accordingly on the prayer of the learned advocate for the respondent numbers 3 and 4, comma, leave is granted to the said learned advocate to file wakalatnama on behalf of respondent numbers 1, 2, 5 and 6 as well within a week from date. Who's of next para? It is pointed out by learned counsel for the parties that the limited ambit of the appeal is a challenge against a final decree of partition by which the commissioner's report, the final report of the partition commissioner was accepted by the learned trial judge. Full stop. As per the said report, comma, since the suit property measures only 1 kota, 6 chataks, 11 square feet, and covered area in each floor is about 585 square feet, comma, it is not a partible property. Full stop. Next para, the commissioner accordingly evaluated the property by relying on an e-assessment slip query obtained from the registration office. Full stop. The property was thus valued by the commissioner at rupees 83,75,112 / Full stop. Next para. It transpires that there is no challenge in principle to the said valuation, and the appellants herein, who claim to be in possession of the property, are agreeable to purchase the shares of all the respondents by payment of the consideration amount pertaining to the share of the said respondents in terms of the preliminary degree and the at the valuation as arrived at by the partition commissioner and accepted in the impugned final decree. Full stop. Next para. Learned counsel appearing for the respondents submits that they are being deprived of the property in the meantime. Full stop. However, comma, since arguable questions have been raised in the appeal, comma, we are of the opinion that the ad interim order of stay granted earlier should continue till disposal of the appeal. Full stop. Accordingly, can 1 of 2024 is disposed of by granting stay of operation of the impugned decree till disposal of the appeal. Full stop. Next para. In view of the learned advocate for the respondent numbers 3 and 4 assuring the court that he will enter appearance on behalf of all the respondents, comma, service of notice of appeal is dispensed with on the respondents. Full stop. The appellant shall the trial court record shall be called for by special messenger at the cost of the appellants to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty is given to the parties to mention the appeal for inclusion as and when the same is ready for hearing. Stop. Next para. However, comma, it is made clear that the learned advocate having instruction to appear for the respondents shall take instructions accordingly from his clients as to whether the respondents are agreeable to proceed on the premise of the valuation in the final decree and to sell their shares in the suit property to the appellants upon the appellants paying commensurate amount pertaining to the shares of the respondents as consideration for the respondent's share, comma, in terms of the valuation arrived at by the partition commissioner. Full stop. In the event the respondents are agreeable to do so, comma, since in any event the respondents have challenged the impugned decree, comma, there shall be no impediment between the parties to settle the matter between themselves on such terms as they deem fit and proper in the light of the above observations. Full stop. If such a settlement is arrived at, comma, leave is granted to the parties to mention the matter for inclusion in the list earlier than the for recording such settlement between the parties. You have not preferred any challenge, therefore you have admitted the valuation. So it remains only on your payment of the their payment of your share to you. You have not preferred any challenge. You cannot have any objection to that. Commissioner has said that the valuation has been given by the commissioner. You have not preferred a challenge. So they'll pay your share.
They have also not agreed on the valuation, my lord. Commissioner's valuation.
You are agreed
But
with
only the
no
objection is raised.
offer being given to them to purchase
Ready
the
to pay ultimate amount that they are refused to accept that.
take it. Take it
Yeah.
and leave the property and be happy with some other property.
My client also willing to purchase the share of the
Kept it open. Purchase it. What prevents you?
I beg to appeal on behalf of the petitioner. Pursuant to Lordship's direction, my lord,
Your
the
Lordship,
respondents have been served.
Your Lordship, I'm happy for respondent number 1 and 2. Kindly keep the matter on the Thursday.
Why?
Your Lordship, the London advocate Omshuna Chakraborty is
Who?
Omshuna Chakraborty is appearing the matter. He left the court for some personal insurgencies. Therefore, he requested me to keep the matter on Thursday. Kindly.
Let us take it. Affidavit of service filed today be kept on record. Full stop. An adjournment is sought on behalf of learned counsel having instruction to appear for the respondents. Full stop. Accordingly, let the matter stand adjourned till
Thursday, Your Lordship.
Thursday we don't take up applications.
Okay, Your Lordship, what is the
Very
feasibility?
well. Till April 24th, 2025, when it will be listed under the same. Let it appear in the list on Thursday. Whenever you take it up.
Much grateful.
Please give your name, sir. Your name.
And can it be on Monday, my lord? If it is taken up on Friday, I am not here, my lord. So if-
Friday we take up single bench.
Ma'am.
If not before Thursday, then automatically it will go.
Me, on the last occasion, I apprehended that they have not filed they might not have filed the Vokalatam, and my apprehension comes true.
They had appeared on the last occasion and directions were
Yes, yes, on 10th March, my lord, if your lordship kindly produce the order of 10th March passed by your lordships. My lord, when I sought for, my lord, service, dispensing in service of notice of appeal, and since they appeared, Mr. Saptoshi Dotto on that day appeared, virtual mode, on virtual mode. Now, my lord,
office was to ascertain. Office report কোথায়?
yes, my lord, on the first.
Oh, আচ্ছা, this. No vocal yes. The trial court records have arrived.
Yes, my lord, I have been served with the notice of appeal.
You prepare the, but
Well,
then
I should-
notice of appeal has been served.
Yes, that has been served.
We'll
my lord, I
proceed with the hearing of the appeal if they have not filed vocal.
my lord, this is with regard to the my lord, visitation of the child. My lord,
We
your
did not
lordship-
dispense with service. Did we dispense with service?
Yes, yes.
Oh, then you have to put in note.
That's the my lord, that's why I apprehended that if they do not file my lord, the Vokalatnama, then I will be in trouble.
Your learned friend has a habit of doing that, or why did you apprehend?
Because I apprehend because my lord,
There must be some reason. Need not disclose it.
no, my lord,
So, what is the stage? The records have arrived. You have already filed paper books.
No. Judge, on
You will
17th, the notice of appeal records has been served upon me.
As rightly apprehended by learned senior counsel appearing for the appellant and expressed on the last occasion, we find from the office report dated April 17, 2025, that although there had been an appearance on behalf of the respondent before the court, and on such premise, the service of notice on the respondent was dispensed with, no vakalatnama has been filed on behalf of the respondent till date. Push up next para. However, learned senior counsel submits that the trial court records have already arrived and a notice to that effect has been given to the appellant. Pushed up next para. Accordingly, in our opinion, there cannot be any impediment in the appellant proceeding with the preparation and filing of the paper books as per our previous direction. Pushed up, however, in view of the changed circumstances, the appellant shall put in due requisites and postal costs
By service by register.
for service of notice of the appeal by registered post on the respondent. Pushed up, such costs and requisites shall be put in within a week from date. Pushed up, upon the service being effected, the service being effected and the requisite number of paper books being filed, the office shall furnish a report as to whether the appeal is otherwise ready for hearing. Push up, liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
One more prayer before your lordship. Only your lordship directed the respondent to bring the child on every Saturday at the South City Mall.
Not bringing.
No, my lord, on the 15th, the first Saturday, she brought the child. On 22nd, she did not turn up. On 29th, she came at 6:30, although it was 5 to 7. When it came at 6:30, on 6th April, did not turn up. What I am praying, subject to your lordship's kind sanction, on the last Friday of every month, let the child be handed over to me after the school hours, and I shall return the child on
Please file a 2-page application on that and serve directly on the respondent. We'll record your submission and we'll say that we request you to file a.
In the meantime, the
No,
system
that whatever order is there will remain.
that will.
At this at this juncture, and senior counsel for the appellant points out that the order of visitation granted by this court is not being complied with to the letter by the respondent, and variation from the said order is sought by the appellant. Push up next para. The appellant is granted leave to file a separate application indicating such violation and seeking the variation as sought for verbally. Pushed up, as and when such application is filed, the appellant shall also serve a copy of the application directly on the respondent. Pushed up, leave is granted to the appellant to mention the said application for inclusion in the list as and when the same has been filed. And in the meantime, the paper book and all these things you go on prepare.
Yes.
If you can, Mr. Rai, can you please just give a server copy of this order or intimate the advocate who appeared for the respondent
Well, I shall,
so that he can do the needful?
well, I shall write a letter to the.
Formally
his
inform him that this
residential
order has
address
been
is
passed.
there,
Yes, yes, yes.
I
To
shall,
the advocate, so that
yes, I shall serve both the orders on 10th March
Better.
as well as these order.
better. You can serve both on the advocate and the
And the
respondent directly.
Yes.
Item number 24, Manoj, I am for the appellant. Mr. Mukherjee is appearing in this matter, Manoj. He is not well. If Madam may kindly take up this matter any day next week.
When should he take it up?
Any day next week, Madam.
On the prayer of the appellant, the matter is adjourned till April 28, 2025.
I'm grateful.
You know Mr. Mukherjee?
I'm grateful.
Yes, Mr. Haldar, what is the matter?
25, my lord, from the stamp reporter's report, it appears that the classification of a field malady, it arises out of a matter final decree.
Partition final degree.
Final decree. So it should be my lord, final decree. It has been recorded, written as order
Oh, we'll grant you liberty immediately
to correct this cost. And another thing is that my lord, through
Yes, another thing is
I am under the impression that the appeal is barred by laws of limitation, but there is no.
report.
It is a
No,
surplusage.
stamp reporter sometimes commits mistake. If you are,
I do not know, my lord, if you also kindly check it up. On
let us
18th,
check up.
18 September 2024, final decree passed. And the final
Stamp reporter often misses, and we have to judgment dated
18th September 2024. Your lordship will find from the certified copy of the order
no final decree
drawn up on 3rd January 2025. From the certified copy it appears.
এটা নিয়ে তো একটা রিপোর্ট দেবে এটা নিয়ে তো রিপোর্ট দেওয়া উচিত ডিগ্রি ড্রন আপ হয়েছে পরে
5th page of the impugned order. It was drawn up on 3rd January 2025, and 4th page of the impugned order. It was passed on 18th September 2024.
yes drawn up is different.
So, and I have applied on my lord 10th of
No,
January.
even if he calculates that period drawing up to be he should have indicated the stamp should have indicated. You have calculated from the limitation after 18th September.
18th September.
From 18th September, 3 months.
From
90 days, I mean.
90 days. I applied for my lord on 10th of January. After my lord drawing of a final decree.
Very well.
So my lord, I will not get any opportunity. Only 90 days would be deducted. But
Right,
there
right.
is no
And
no
it
report.
finishes approximately on 17th of December.
18th.
16th, 17th.
I am telling my lord.
No, cannot be 18th.
September, October, November, December.
December.
17th December or
17th
16th December.
approximately should be 17th.
16th or 17th December.
You have to explain the period after that.
Yes, my lord. Because I have to wait.
You applied after that.
After that, because I am not waiting for drawing of a final decree.
Maybe. So that is the reason.
But there is no report from the stamp reporters.
So we are not bound by the report of the stamp reporter. If you have filed a section 5, what is the delay?
My lord, I have explained, my lord, the appellant number 1, my lord, was suffering from illness and he was undergone, my lord, surgery, my lord, on 25th of.
What about appellant number 2, Mr. Haldar?
My lord, he was, my lord, taking care of.
One was taking care.
He was taking the.
Oh, 2 was taking care of one and 1 was taking care of the litigation.
No.
And both are taking care of you.
Both are brothers, my lord. And I have, my lord, annexed all the papers.
What is the delay according to your calculation?
It should be, my lord, I am telling 73 days.
Serve a copy and come back, we'll condemn it.
My lord.
Although it is pointed out by learned counsel for the appellant that there is no report of the stamp reporter regarding delay in preferring the appeal, we find prima facie that the appellant is justified in taking out an application for condonation of delay, since the application for certified copy itself was filed in the court below after the expiry of the limitation period. Whoso be that as it may, the appellant shall serve this arises from what suit, Mr. Haldar?
Partition suit.
Preliminary degree?
Final decree.
You have to serve all then.
My lord.
Serve a copy of the serve copies of the application on the plaintiff stroke respondent number 1 as well as the pro forma respondents. Did they contest in the court below the others?
My lord, some of them contested.
Better try to serve, we will consider that. As well as the pro forma respondents indicating that the application shall be listed on May 6, 2025 when an affidavit of service to that effect shall be filed by the applicants. Come back on that day, just check up in the meantime which of them contested and we can just take care of that.
My lord, in the meantime, my lord, there is, my lord, we have challenged the preliminary decree also. But during pendency of the appeal,
In the same appeal, you cannot challenge both.
no, my lord, another appeal. My lord, but
That
during
is also time barred.
that is also time barred, but during pendency of the appeal, my lord, final decree has been passed. That
That
is
appeal is
also
still
pending. That is also
So
pending.
we'll take that up also. We'll direct the two to be heard analogously.
My lord,
Because the legal effect is that you had already preferred that appeal.
my lord,
We have to hear that also. Or it does not get automatically infructuous.
my lord.
Because that preferred at the relevant after you cannot challenge in a single appeal,
No, no, no,
and after final degree is passed, you cannot challenge that.
no, my lord.
But you preferred that appeal before that.
Before that,
So if you win that, then the final degree will be affected in any event. We'll take up both the appeals together. No difficulty on that.
my lord.
You point out to us
My
when if we condone the delay, as and when we condone the delay application, we'll direct you to direct the two appeals to be heard analogously and pass necessary orders. Analogous hearing and all that. Remind us when you take up this section.
My lord.
Item number 26, my lord, I appear for the appellant.
Yes.
My lord, by the last order, my lord, I was directed to serve the respondents.
Some of the respondents have.
Yes, there are four.
One only.
My lord, we have served on all four respondents,
All
but
have
the
received.
main respondent, my lord, who is the respondent number 1 and the defendant,
All have received.
he has refused service.
Who has refused?
The respondent number 1. Yes, my lord, the main.
Refusal is good service.
Yes.
Where do you get he has refused? The track report says that.
Yes, my lord. My lord will kindly come to page 6, serial number 4, item return refused.
Yes, yes. What is the application for? What is the appeal for?
Yes, my lord. My lord, this appeal is against an order dated 12th December 2024, by which an application under Order 7, Rule 11 was allowed and my plaint was rejected. My lord, the rejection was done on the grounds that the plaint has no cause of action. My lord, this issue was never raised in the application under Order 7, Rule 11, and what the learned court has done it has gone into a mini trial and decided by itself that the cause of action as espoused in the plaint is fishy and is not present.
No, that cannot be a ground.
That-
Non-disclosure can be a ground.
No, my lord,
If you have disclosed, it cannot be decided on merit at the order.
yes, my lord, that is what they have done, and they specifically said that we are not.
What is the scope of stay?
No, my lord will kindly recall.
Means there is no suit now.
No, my lord will kindly recall in the last order, my lord has also observed perhaps that the stay, my lord had not granted, but on the basis of the application, my lord, today was fixed for final hearing of the appeal.
Oh, acha. Yes.
Yes, my lord.
Place the impugned judge.
Yes, my lord. My lord, may I just in a nutshell tell my lord what the case is about, my lord? My lord, this suit has been filed by me. I am the appellant is the plaintiff.
You are Mr. Mitro.
Yes, my lord.
Mr. Mitro, can we just see the impugned judgment once, then come back?
Yes, my lord.
Let us do that first because then we'll know what to look for.
Yes, my lord. My lord will kindly come to page
We'll
16. It starts.
we'll look at the memo. Page 16.
Of the stay application. My lord. Oh, I'm
just refer to the internal page. You can replace the entire judgment also.
very well, my lord. My lord, internal page 1, my lord. My lord will firstly come to para 3. There's a reference, my lord, will come in line number 3, but in terms of the at the very outset of this order, it is pertinent to mention here that the application filed under Order 7, Rule 11 was already decided by this court. By the learned.
Which paragraph? Which paragraph?
Para number 3, my lord. It's not numbered.
In this
Internal page 1.
In this context.
At the very outset, my lord.
Whose order? The trial court, the impugned judgment you're reading?
Yes, my lord.
In our order number 22 dated 12th of December.
Order number 20, yes, my lord.
Third paragraph is something.
No, at the very outset, my lord.
Sorry, I was looking at a different page. Every page gives a caption. That's right. Sorry, please continue. At the
Yes,
outset.
Madam. At the very outset of this order, it is pertinent to mention here that the application filed under Order 7 Rule 11 was already decided by this court by the learned erstwhile presiding officer. But in terms of the order passed by the Honorable High Court, Calcutta, the case record is again taken up for hearing in respect of the application filed under Order 7 Rule 11 of the CPC.
What is the background of this?
Yes, Madam. That's why I was saying. Well, I'll just put it in a nutshell. This case arises out of an agreement for sale.
You want a specific performance?
Yes, my lord. I have filed a suit for specific performance. I have made payments of money. Consideration has been paid and accepted till 2021. Suit filed in 2022. After I filed the suit, the defendant number 1, with whom I have the agreement of sale, who was supposed to execute the final deed of convenience, has failed to do so despite taking money from me. He has first filed an application under Section 5 of the Limitation Act, saying that the suit is barred by limitation, and therefore you'd please dismiss the suit.
There can be Section 5 application.
That is what they have filed, Mala.
Section 3 is the relevant provision. The court has to look in.
I bow down, but that is what they have filed.
They take a defense. Let us forget the caption.
Yes,
They take a defense of limitation.
Yes, they have taken the defense of limitation. That
Right.
defense has been struck out by the lower court and the lower court has said that whether or not performance of the contract was refused, when it was refused, that is a matter for trial. This was done, Ballot, by the order dated 21st November 2022, which is at page 36, Malad. I'll take Malad. Malad will kindly come to page 36 once. But the operative portion, Malad, will kindly take up page 38 once.
Yes.
Page 38, the third para from the end. This court has meticulously gone through the entire citation, wherefrom it appears that if the date fixed for performance, or if such no date is fixed, when the plaintiff has noticed that performance is refused. Here in the instant case, the performance has been refused by the defendant number 1. It is well settled that at this stage, only averments in the plaint are to be looked into, and from a reading of the averments in the plaint, in the case in hand, it cannot be said that the suit is barred by limitation. The issue as to when the plaintiff had noticed refusal is an issue which can be adjudicated after trial. Madam will kindly note this, because in the impugned order, this specific issue has been taken as a ground for alleged absence of cause of action. Well, this order also subsequently it's affirmed by the Honorable High Court in a revision filed by it. I'll come to that later. But after the Section 5 is rejected, they again filed a Order 7 Rule 11, which is at page 32. In the Order 7 Rule 11, they take the ground that the suit is undervalued and the court fee is not paid. It is at page 32, my lord. However, my lord, when the matter is taken, we file a written objection. However, my lord, when the matter is taken up for hearing, they once again reiterated the argument that the suit is barred by limitation and therefore dismiss it. Therefore, my lord, in the order dated 30th November 2022, which is at page 40, my lord, will find that the learned lower court says that we have already decided this issue. We will not re-agitate it again. Therefore, we are not entertaining the Order 7 Rule 11 application.
That limitation issue was the only issue they raised against the second
They
time.
again raised it. My lord will kindly
That was not the issue of undervaluation was not raised at all. Not
raised at all.
So court rightly said that it has
Yes, my lord.
Then what
and then my lord will kindly bear with me in page 41, which continues of the order. My lord, in 41, in the second portion where I have prayed for an injunction, my lord will kindly read from the line, defendant number 1. This is the paragraph, second last paragraph. Yes, it's defendant number 1 preferred to file several petitions to delay the matter of hearing of injunction petition, but the defendant number 1 preferred not to file a written objection in the against the instant application for injunction till date. Considering the urgency in the matter, petition for injunction is to be disposed, though the defendant number 1 tried his best to delay the hearing, which is evident from the record. Therefore, my lord, the injunction application is taken on record, a prima facie case is made out, and a stay is granted in my favor. After this, my lord, they file a civil revision before the Honorable High Court against the order in respect of the Section 5 limitation and the first Order 7 Rule 11 filed by them. The Honorable High Court passed an order dated 28 April 2022, which my lord will find in page 44. It affirms the order which says that limitation is an issue that has to be decided in trial. Has my lord gone to page 44? My lord, we'll kindly see the last para in page 44 on careful perusal of the order number 4 dated 21st November 2022.
We have seen 45 also.
Yes, my
Mixed
lord.
question and all.
Yes, my lord. My lord, we will kindly come to page 45 once.
Seen that also.
So what happens, my lord? The Honorable High Court says that, okay, the limitation is decided, but you did not go into the issue of deficit quote. Please rehear. So, my lord, as per the High Court's direction, the order 7 rule 11 was to be reheard again. But what they do is
Why was it kept for rehearing? We don't understand.
Because the
Deficit quote fee issue.
Yes, High Court opined that since that was there in the pleadings, even though that was never agitated, kindly rehear them. But instead of rehearing the order 7 rule 11, the defendant number 1 files a fresh order 7 rule 11, which is in page 46, which is more or less a copy paste of the first order 7 rule 11, my lord. Here also the ground of deficit court fee and undervaluation is raised. My lord, arguments are advanced, written objection is filed by me. We also go to the court and we pray for an opportunity to rectify the suit valuation if there is any defect be found. My lord, now, my lord, the impugned order, my lord, will kindly come at page 6 of the stay application. Or my lord, what the impugned order does is, the impugned order holds that there may perhaps be some undervaluation, in some incorrect valuation. It also records, and my lord, I am reading from internal page 2, para 4. On the other hand, a learned counsel for the plaintiff, that is the appellant before my lord, learned counsel for the plaintiff submitted that the value of the suit is mistakenly shown as 99, which was not an intentional one, and accordingly he prayed for necessary correction of the same. Now, my lord, firstly, my lord, this wrong valuation by itself cannot be a ground for rejection of a plaint. My lord, may I place order 7 rule 11 clause B, my lord.
Even then an opportunity
has to be given. And I
undervaluation and
I pray for an opportunity.
Yes, absolutely.
But that is not given. What they do, my lord, is my lord will kindly come to internal page 5. What they do is they go and conduct a mini trial and say that the suit is bereft of any cause of action. Why? Because
cause of action was not even a ground taken in the 711.
No. They do it by themselves and they say that the date of refusal is not clear, the quantum payable is not clear, when refusal was.
Let us please read that question. Yes.
Yes.
So, 711B empowers a court. What is the court's finding on 11B?
11B, my lord, will the finding is at internal page 2.
That is the, yes, it carries on. What is the?
Yes. Now, my lord, in internal page 5 onwards, my lord will come to the finding as far as the purported lack of cause of action.
No. What happens to this undervaluation? What does the court say on that?
My lord, the court finds that there is an undervaluation pertinent to mention here. Orders will carefully go into things. It is at internal page 3. Appears to me that the value as shown in the cost title of the suit does not match with the above of the plain. So, prima facie, to the best of my prudence, I ponder that the suit is undervalued. In this context,
this page 3, internal page 3.
Yes, internal page 3, my lord. I'm so sorry.
Which paragraph?
It starts from para 2, my lord.
It appears to me, yes.
Yes, my lord.
Prima facie, yes. Of my prudence, I consider such and such.
There is no express direction for us to rectify. Instead, my lord, in internal page 5, the cause of action is the purported lack of cause of action has been discussed and the plaint has been rejected on that ground.
We will discuss further. No, it says ultimately, whatever may be the language, it says that you have not disclosed cause of action, only 2 dates are shown by you. No specific date mentioned in the plaint as to the agreement, date of performance. Let us see the plaint once.
Yes, my lord. My lord, will kindly come to page 27. My lord, page 27 contains the parties 1A to 1C are the plaint appellants before my lord. From page 28 onwards, my lord. May I place the para, my lord? My lord, that one written agreement for sale was executed voluntarily by the defendant Sukumar Mukhopadhyay, alias Shadon, son of such and such, resident of such and such, for the selling of 46 quota in favor of the plaintiffs and pro forma defendant number 2 on 20th April 2019. Date of sale is mentioned, my lord, in connection with the plot details such and such are given. My lord, the para
The
2,
pro forma defendants, they have
my lord, the pro forma defendant number 2 is one of the buyers in
they
the
are
agreement of
subsequently
sale.
purchased.
No,
from-
no. The pro forma, the buyers are the plaintiffs.
Buyers means they were co-agreement holders with you.
Yes, my lord. Yes, my lord.
Let us continue.
Yes,
Yes, with the plaint.
In para 2, my lord, I am reading that the defendant is a Shebite of the said suit plot stated in the schedule below, for which he has agreed to sell to the plaintiffs. Para 3, that the plaintiffs and pro forma defendant number 2 have paid rupees 10 lakhs to the defendant number 1 at the time of execution of agreement to sale dated 20th April 2019, and rupees 1 lakh through check bearing such and such dated such and such drawn on UCO Bank Bishnupur branch in favor of defendant number 1 issued by Shivdas Guru, younger brother of plaintiff number 1. And after that, the plaintiff has been in lawful possession of the suit plot stated in the schedule below as part performance under 53A of the Transfer of Property Act. At present, the defendant is intentionally transferring the suit plot to some stranger for higher value in deprivation of plaintiff, for which the plaintiff is ready to pay the rest amount to the defendant number 1 for entire portion of suit plot as was agreed by the defendant number 1 with plaintiffs and pro forma defendant number 2. It is pertinent to mention here that the plaintiff number 1 has already defrayed more than 15 lakhs. Whatever were done by
we
the...
are satisfied. Judgment হবে, judgment format হবে. Affidavit of service filed to be kept on record, full stop. In our order dated March 25, 2025, we had categorically observed that in view of the short ambit of the appeal, the service of notice along with copy of the application and the memorandum of appeal would be deemed to be sufficient service of notice of hearing of the appeal as well. Full stop. Next para. Despite such service as borne out by the affidavit of service, please take your seat. None appears on behalf of the contesting respondent when the matter is called on for hearing today. Push up as such, we take up the appeal for hearing ex parte. Pushed up. The present appeal arises out of a deemed decree rejecting the plaint of the appellant's suit for specific performance, primarily on the ground that no cause of action has been made out in the plaint. Pushed up. The brief history of the case is that the suit was filed by the plaintiffs stroke appellants on the for a decree of specific performance of an agreement for sale. Pushed up. Next para. Initially, an application, captioned peculiarly to be one under section 5 of the Limitation Act, was filed by the defendant number 1 stroke respondent number 1, primarily raising an objection as to the suit being barred by limitation. Full stop. The learned trial judge turned down such objection. First instance also a revision was preferred when the section 5 was rejected.
No, my lord. One revision collectively for both orders, section 5 order and first order 711 order.
Very. Next para. Subsequently, an application for rejection of the plaint was filed by the defendant number 1 under order 7 rule 11 of the Code of Civil Procedure, this time on the ground that the suit was undervalued. Full stop. While advancing arguments, however, the defendant number 1 stroke respondent number 1 took the self-same objection of the suit being barred by limitation, which had already been decided at the first instance by the learned trial judge. Full stop. As such, the application under Order 7, Rule 11 of the court was turned down by the learned trial judge. Full stop. Being aggrieved collectively by the order of rejection of the prior Section 5 application as well as the subsequent Order 7, Rule 11 application, the defendant number 1 stroke respondent number 1 preferred a revisional application before this court, which was disposed of by a learned single judge of this court, vide order dated April 28, 2023 in CO 355 of 2023. Full stop. The learned single judge affirmed the finding of the learned trial judge that the issue of limitation was a mixed question of law and fact, and as such can be raised only at the time of trial, and affirmed the dismissal of the application for rejection of plaint on such ground. Full stop. However, the matter was remanded to the learned trial judge for a rehearing of the application under Order 7, Rule 11 of the Code of Civil Procedure for the purpose of ascertaining on the other issue as to whether the suit was undervalued and or deficit court fees had been put in. Full stop. Next para. This time, instead of having a rehearing on the self-same application under Order 7, Rule 11 of the Code, as intended by the learned single judge, the defendant stroke respondent number 1 filed a fresh application under Order 7, Rule 11 of the Code of Civil Procedure. Full stop. Reiterating the arguments made on the earlier occasion as to the suit being undervalued. Full stop. Next para. In respect of undervaluation, however, the learned trial judge, by the impugned order within bracket deemed decree, bracket closed, that the plaintiff categorically took a stand that the value of the suit was mistakenly shown as ₹99, which was not intentional, and accordingly he paid for necessary correction of the same. Full stop. It is also submitted before this court on behalf of the appellant that the appellant is agreeable to effect the necessary amendment to the plaint and correct the valuation as well as pay the court fees according to the revised valuation. Full stop. Next para. However, the learned trial judge, even after recording such submission of the plaintiff stroke appellant, went on a tangent and entered into an exercise as to whether cause of action was shown properly in the plaint. Full stop. After an extensive quotation of Section 12 and Section 10 of the Specific Relief Act 1963, the learned trial judge held that after formal perusal of the plaint, it appeared to the court that cause of action for filing of the suit was shown by the plaintiff on August 31, 2022, whereas in the averments of the plaint, there was no whisper regarding any specific amount promised to be paid by the intending purchaser to the intending seller within any specific period. So it was further observed that how cause of action arose on August 31, 2022 was not shown by the plaintiff, and there was no whisper in the plaint regarding any issuance of letter requesting the defendant to perform his duty as per terms of the agreement for sale and stroke or any specific date of denial or refusal by the defendant was not shown. Full stop. The learned trial judge observed that only 2 dates were mentioned in the plaint, which are April 20, 2019 and August 10, 2021, but it was within double inverted, totally haze, HAZD, totally haze, double inverted close, এই দুটো words শুধু double inverted, pertaining to the date of cause of action as shown in the plaint. Full stop. The learned trial judge went on to observe in the impugned deemed decree that something was fishy pertaining to the cause of action, which was shown after 1 year from the date of payment, Full stop. The court observed that it had not done a mini trial, but that it did not find any proper cause of action for filing the suit, comma, particularly when the plaintiff proposes to perform his duty, but defendant disposes. Defendant disposes to double inverted মধ্যে. Full stop. It was also observed that it is very surprising that specific amount remaining after the part performance, which was to be paid fully by the plaintiff, was neither mentioned in the plaint nor mentioned in the alleged agreement for sale, and so no specific date being so mentioned, comma, it was clear to the court that the plaintiff had failed to show proper cause of action for filing the suit as prescribed under section 12 of the Specific Relief Act. Full stop. On such premise, comma, the learned trial judge proceeded to reject the plaint of the plaintiff stroke appellant, comma, agreed by which the present appeal has been preferred. Full stop. Next para. Order 7, Rule 11 of the Code of Civil Procedure envisages a rejection of plaint only under certain specific yardsticks having been met, MET. Full stop. The German grounds are found in clauses small a within bracket, small b within bracket, and small c within bracket of Rule 11. Full stop. Next para. Insofar as undervaluation or insufficient payment of court fees is concerned, comma, the said provision mandates the court to give an opportunity to the plaintiff to correct the valuation and stroke or put in the proper court fees, and if even after such opportunity being given, comma, the same is not done, only then to proceed to reject the plaint. Full stop. Next para. Such question does not arise in the present case, comma, since the plaintiff expressed its willingness to correct the valuation and put in proper court fees, and no opportunity was given by the court to the plaintiff to do the same, comma, nor was the plaint ultimately rejected on grounds small b and or small c of Order 7, Rule 11 of the court. Full stop. Clause small a within bracket of Rule 11 of Order 7 of the Code clearly mentions that the ground for rejection of a plaint may be where the plaint within double inverted does not disclose, double inverted clause, a cause of action. Full stop. It is to be kept in mind that the ground envisages a non-disclosure of cause of action, and not that there is no cause of action for filing of the suit. Full stop. There is a not subtle, not so subtle distinction between the two, inasmuch as non-disclosure of the plaint can be deciphered from the plain reading of the plaint itself, whereas to find out whether any cause of action is actually involved in the suit, comma, the court has to undertake a full-fledged trial on evidence. Full stop. In the present case, comma, however, comma, the learned trial judge apparently proceeded on the premise that the plaintiff had no cause of action for filing of the suit. Full stop. Next para. Even giving the benefit of doubt to the learned trial judge and construing that the plaint was rejected under clause small a, comma, on the premise that no cause of action was disclosed, comma, we are unable to accept the findings and conclusions of the learned trial judge. Full stop. The learned trial judge unnecessarily insisted on specific dates being mentioned for payment of the amount due as well as the exact amount due. Full stop. However, comma, the Specific Relief Act does not mandate the plaintiff to disclose all particulars possible with regard to the cause of action, and or to plead the evidence which shall be laid by the plaintiff ultimately in the suit. Full stop. What is to be seen is whether the bare foundation of a cause of action are disclosed in the plaint for the plaintiff to have filed the suit at the stage of Order 7, Rule 11 of the Code of Civil Procedure. Full stop. In paragraph number 1 of the plaint, comma, the plaintiff categorically mentions about a written agreement and puts a date to the same, comma, being April 20, 2019. Full stop. Next para. In paragraph number 3 of the plaint, comma, the plaintiff also categorically mentioned that an amount of rupees 10 lakh was paid to the defendant number 1 at the time of execution of the agreement to sale, and that rupees 1 lakh was paid through check, comma, the number and particulars of which were also given in paragraph number 3 of the plaint. Full stop. Next para. Moreover, comma, the plaintiff stated in the self-same paragraph that the plaintiff had been in lawful occupation, lawful possession of the suit plot in part performance of the agreement under section 53 capital A of the Transfer of Property Act, and that the defendant was intentionally transferring the suit plot to some stranger for higher value, তারপর double inverted, in deprivation of the plaintiff, double inverted close, comma, for which the plaintiff was ready to pay the rest amount to the defendant number 1 for entire portion of the suit plot to be sold to the plaintiff. Full stop. Next para. Thus, comma, by pleading the fact that the defendant number 1 was intentionally seeking to transfer the suit plot in favor of a third party, comma, it can definitely be construed that such attempt on the part of the defendant number 1 itself can be construed to be a refusal to perform specifically perform the agreement between the parties as pleaded in paragraph number 1 of the plaint. Full stop. Hence, comma, a sufficient cause of action was disclosed in the plaint itself. Full stop. The plaintiff, comma, the plaintiff number 1, comma, it was also pleaded, comma, had already defrayed more than rupees 15 lakh towards the suit plot for appreciation and development of the same. Full stop. In paragraph 5, comma, the plaintiffs pleaded that the plaintiffs and the pro forma defendant number 2 were ready to pay the rest of the amount to the defendant number 1 after payment of total rupees 11 lakh agreed price for the execution and registration of the sale deed. Full stop. Next para. In paragraph number 7, comma, it was stated that the cause of action has arisen on August 31, 2022. Full stop. Although it is not clear from the plaint itself as to what happened on August 31, 2022, comma, it cannot be said on a plain reading of the plaint that the plaintiff should have been shut out on the ground that no cause of action was disclosed on such ground alone. Full stop. Read in conjunction, comma, paragraphs 3, comma, 6 and 7 clearly indicate that the defendant number 1 was attempting to transfer the property in respect of a third party, comma, thereby refusing to perform the agreement with the plaintiffs, comma, to which a date was put as August 31, 2022. Full stop. It is always open for the plaintiff to fill in further details, comma, if necessary by amendment of the plaint and or in evidence. Full stop. However, comma, we find that the foundation of the necessary pleadings to satisfy the relevant parameters of the specific relief act are already there in the plaint, and as such, comma, the learned trial judge palpably erred in law in holding at the outset that no cause of action was disclosed at all in the plaint. Full stop. Thus, comma, we are unable to agree with the conclusions and findings in the impugned deemed decree. Full stop. In degree, comma, insofar as the same rejects the plaint of the appellant's suit. Full stop. Next para. The vacating of the ad interim order of injunction was consequential, and as such, we can also look into the same within the conspectus of the present appeal. Full stop. in view of the above observations, comma, FA 119 of 2025 is allowed ex parte, comma, thereby setting aside the impugned judgment and deemed decree dated December 12, 2024, comma, whereby the plaint of title suit number 97 of 2022 was rejected. Full stop. We accordingly set aside the impugned judgment and deemed decree dated December 12, 2024, passed by the learned civil judge, senior division at Bishnupur, District, Bankura, in title suit number 97 of 2022, and restored the plaint of the said suit to its original position. Full stop. Next para. Insofar as the admitted undervaluation of the suit is concerned, comma, we direct the learned trial judge to grant an opportunity and fix a date for the plaintiffs to carry out the necessary amendment insofar as the valuation of the suit is concerned, and to put in the deficit court fees, if any, comma, commensurate with the revised valuation of the suit, comma, also within a limited period. Full stop. We make it clear, comma, however, comma, that in the event the plaintiffs fail to comply with the said stipulated time to correct the valuation and or put in the deficit court fees, comma, it will then be open to the learned trial judge to consider as to whether clauses B and C, small b and small c within bracket, of Order 7 Rule 11 of the court applies, and to proceed accordingly. Full stop. Next para. However, comma, accordingly, the matter is remanded to the court below for proceeding with the suit on merits in the light of the observations made above. Full stop. Since the ad interim order of injunction, which was subsisting on the date of the impugned decree, was vacated only on the ground of rejection of the plaint, comma, as a consequence of setting aside the said decree, comma, we set aside such portion of the decree as well, whereby the ad interim injunction subsisting then was vacated, and restored the said injunction order as it was before the date of the impugned judgment and deemed decree. Full stop. Bas. Can 1 of 2025 stands disposed of accordingly as well. No rest to cost. Thank you.
Grateful, my lord.
এটাতে ডিগ্রি ড্রন আপ হবে কিনা আমার একটু ডাউট আছে, কারণ ডিম ডিগ্রি তো যদি ড্রন আপ হয়, অর্ডার 7 রুল 11 একটু ডিপার্টমেন্টে খোঁজ নেবে, যদি ড্রন আপ হয় তাহলে ওটা একটু ঢুকিয়ে দেবেন, ফর্মাল ডিগ্রি ড্রন আপ। আমি একটু চেক করে নিচ্ছি। থ্যাংক ইউ।
Lord, item number 27, my lord, I am for that. It is a short matter. My lord, if
It is 126
no,
now.
my lord, can it be tomorrow, my lord?
No, today at 2.
I am for the appeal.
Yes.
Last occasion, my lord, directed me to serve respondents. My lord, I have served, my lord, this is my affidavit of service. It's a case of pre-mortgage tenancy, my lord.
We'll continue the injunction. Good service affected.
My lord, landlord unclaimed. My lord, landlord did not even, in the court below also did not appear.
Unclaimed
Suit
is
was
good
running
service.
ex parte against him.
Unclaimed is good service. We find from the affidavit of service, which is kept on record, that proper service has been effected on the respondents. Full stop. We further find from the averments in the injunction application that a prima facie case for hearing the appeal on merits has been made out, which of the balance of convenience and inconvenience as well as irreparable injury ingredients are also in favor of grant of injunction. Full stop. Accordingly, can 1 of 2025 is disposed of by restraining the respondents by an order of injunction from disturbing the peaceful possession and enjoyment of the plaintiff appellant in respect of the suit property without due process of law till disposal of the appeal. Full stop. There will be no rise to cost. The appellant shall put in due requisites and postal costs for service of notice of the appeal on the respondents, indicating them. Within a week from date, the trial court record shall the trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you.
Deeply obliged, my lord.
For the respondents,
My lord, if it pleases your lordships, my lord, I beg to appear for the appellant, my lord. My lord, it's an after notice matter, my lord.
not before my landed and service. But your lordships, as per your lordships, direction not passed on 23rd of March. Now the copy of the application has been served, but not in due compliance of your lordship's order, curing the defect. And most of the pages are these, my lord, not the legible copies, my lord. Even the appeal also has not been served, my lord.
Appeal need not have been served, but
But the copy is not, it is an application.
these are
for
illegible
appropriate
copies.
order.
These are illegible copies.
My lord, I bow
Your
down,
lordship,
but
kindly
the
see.
question involved is a pure question of law, my lord.
No, but serve a
That
proper
has-
copy.
The legible copies have to be served. my
Learned
lord.
counsel you are for all the respondents.
All the respondents.
Learned counsel appearing for the respondents points out to the court that illegible copies of the annexures to the application has been served on the respondents. Full stop. Accordingly, the learned advocate for the appellant is directed to serve a proper and legible copy of the entire application on his counterpart appearing for the respondents during the course of the day. Full stop. The matter shall be taken up for hearing tomorrow. We are taking up.
Tomorrow or next week, ma'am. Next week.
Well, shall be taken up for hearing under the same hearing on April 28, 2025.
Yes.
My
What
lord,
are you doing?
my-
What is that copy?
these are, my lord,
Similar.
All the
similar,
pages
my
are like that.
Let us see our copy.
All the pages, almost all the pages.
my lord, page 31.
Always the judges copies are served.
Our copies are marginally better. We can just be similar, but we can see through and look at the other pages are all right. The other pages are all right in our
My
copy.
copy, other
Look at his copy.
My lord,
You exchange copies and you
my
argue.
lord, yes, my lord. I have my copy, my lord.
let him
Give a
let him
copy.
service his copy.
Give a proper copy.
20.
28.
I'm grateful.
Originals must be with your client.
That's what I will direct my client to come and.
You have got 1 week because
I'm grateful. It is.
Lordship, item number 29, I am on behalf of the appellant. I am on behalf of the respondent, Lordship. I am on behalf of the respondent.
rupees 4 has been filed now. Where you deposited?
My lord,
Tolaban of rupees 4 was to be deposited.
they've appeared.
For the appeal, you have to. Rupees 4 today.
I shall.
Yes, what
My
is the
lord,
application?
last application for alimony pendentility, last direction was upon me to file my affidavit of assets, which have served upon them on 21st of March. Today itself, 10 minutes ago, I've received their reply. In any way, in view of the admissions made by them, my lord, I'm ready otherwise. I don't need to file and reply.
Where is your opposition? File it.
Actually, Lordship, due to health issue of the respondent, delay occurred.
All right.
There's a child of 11.
You don't want to use a further reply to this?
No. If my lord, I shall. My lord, they have categorically admitted my claims.
No, you take your choice. After hearing the matter, we won't permit.
Very well. I don't have to reply.
Very well. What is the matter?
There's a 5-year-old child, the 11-year-old child who studies in class 5. Now, I suffered an ex parte decree. I've assailed that before this honorable court. Now, my lord,
Lordship, in that.
What in that?
Lordship, in that event, I am under compulsion to reveal one thing that for my daughter, I have given entire expenses.
We'll
for
hear
her
you
study.
when we hear you. Please argue when we hear you. Let him complete.
Lordship,
Yes.
Lordship.
now, my lord, since his contentions is that we have admitted that he pays for the month school and other curriculums he pays. Now, my lord, otherwise than that, my lord, I'm residing at my own matrimonial house. I'm housewife, and other than that, I have prayed for 15,000.
He resides elsewhere.
No, he resides at he's a permanent school teacher, properly appointed permanent school teacher at a school at Nodia. Government school. He resides there. He comes and goes on the weekends. And I have attempted to go over there. I have
This
not been
appeal is
allowed.
against what? Your divorce decree refused.
No, their divorce decree, ex parte divorce decree.
Granted.
Granted.
Very
No, my lord,
so what about the alimony? What have you claimed for yourself?
15,000 for myself only, and the child 30,000. Now, my lord, in their opposition, they have admitted that the child requires 30,000. Page 6.
How much are they paying?
They are paying odd amount of. They have admitted 500 per month for drawing classes, 1,000 per month for violin
What is the
classes.
total they have admitted?
In and around 3,000. 2 to 3,000.
Where have they admitted? Let us see that admission.
Page 6 of their affidavit in opposition, of their independent affidavit in opposition.
Yes.
Affidavit of assets and liabilities of their
assets.
Now, I'll point out, my lord, they have also given the pay slip. Their gross salary is, my lord, 85,000 odd. We iterated of 70.
Where have they admitted that 30,000?
Page 6. Internal page 6. Details of the children of the parties. Expenditure of monthly maintenance of the children.
So that adds up to.
That's adds up to my contention. And my lord, the pay slip is page 8. Page 8 of their opposition to my application for alimony pendently. It's captioned as such. My lord, pay slip. My lord, at the bottom from the right, it is 1, 2, 3, 4, 5, 6, 7, 8, 9. 85,000. This is the gross salary.
They have shown deductions also. So
deductions.
7,54,000. What does it translate to per month?
Transit to per month, my lord, it's according to them, it's 65,000 odd.
Per month.
Per month. That is their contention. Other than that,
And for yourself, you have asked for 15. And
child 30.
Child is son.
No, daughter.
So 30 plus 15, 45,000.
45.
They earned 65.
65, and other than that, they have admitted they are claiming rent from a rental property of 3,500. That is there. I'm
so it comes to around rupees 70,000.
70,000 odd.
So what is the 1/5 of that?
1/5 of that is around 14.
1/3?
1/3 is 23,000 odd. 24 goes to 72.
70,000.
23 or 69 it comes to.
23,000 per month. 30, you are not earning anything.
No, I'm a housewife and I have no parental home. Both my parents are deceased. I have nowhere to go. I'm currently at matrimonial home. I had to seek an injunction from your lordships so that I don't be driven out of the matrimonial
Let us hear them.
home.
Yes. What do you say?
Lordship, in that event, Lordship, kindly fixed a date for hearing, Lordship.
No, this is the date for hearing. What will you have admitted child expenses to be 30,000. So you have to pay that at least and something for the wife.
Lordship, in that event, I am under compulsion to say that one Shukonna scheme has been opened for my daughter, and I am paying regular contribution in this
What is the
account.
payment she receives under Sukonna or whatever?
Lordship, actually, I am paying through online, Lordship.
No, stop the Sukanna payment, pay her directly 30,000 for the daughter.
30,000.
And what about the wife? Sukanna scheme, close it. No
And
Sukanna,
Lordship,
directly pay to your
and
wife.
Lordship, the vital thing is that
Why
the
should she
wife
run from
is,
pillar to post for your child expenses? Some scheme or don't continue with the scheme. Pay her directly.
Lordship, as per Lordship's direction, definitely I will pay directly. But Lordship,
70,000, 30,000 you have to pay. Yes, by?
My wife is residing in my flat.
No,
And Lordship,
we are not directing you to pay anything for her residence, but for standard of a minimum standard of living, what do you do? What is your job? You're a teacher, permanent teacher.
Lordship, I am a teacher. But Lordship, I am paying the electric bill. I am paying all expenses.
Yes, but
Lordship.
one does not live by electric bill and residence only. She has to eat. She has to live her livelihood. She has certain minimum expenses. A lady has her expenses.
For her daily bread and butter also I am paying, Lordship.
No. How are you paying for her bread and butter?
Lordship, on several times, Lordship, I am paying the
If
money.
you are paying that now we'll direct you to pay. We'll make that, we'll regularize.
But Lordship, 30,000, it is kindly consider, Lordship, 30,000, kindly consider, Lordship. I am paying for your Lordship's. Lordship is not audible. Lordships are not audible.